Good morning. Hello, everyone. Thank you for joining us today for the February 16th, 2023 Workers' Compensation Roundtable. Today, we have Attorney Rich Goldburg joining us. He will be speaking to us about wage loss compensation. Rich is a very experienced workers' comp attorney. He has been practicing for a number of years.
Forever.
Rich. I didn't even think to look at your bios to introduce you because I've known you for so long.
Put it this way, I have practiced workers' comp defense law in 5 different decades. That probably says it all right there.
I think that does. I think that and I remembered that you were a Rutgers grad. Now that I see that, so we will go ahead and we will get started. We're running a couple of minutes behind, so we'll go ahead and get started and turn things over to Rich. And I will share my screen so that you can see the outline. Okay.
Yeah.
Go ahead, Rich.
All right. Well, so as the outline shows, I am with the firm of Scott Scriven LLP. I've been a partner at the firm since 1999. And I've been with the firm really since it started in 1995. Before then, I was with Squire, Sanders, and Dempsey, no longer known by that name, but big firm in Columbus. And they still exist. They just don't go by that name. And been doing workers' comp defense really almost exclusively since the early 1990s. So about 30 years. Certainly, one of the areas that I've seen a lot of changes is wage loss. Maybe not that much in the last decade, but before the wage loss rule went in effect, I think in 2014, there was at times almost a Wild West in some of the areas of wage loss that we would deal with as to how a hearing officer would deal with it, because the rule really wasn't all that specific, and a lot of things had changed in about how people went about trying to get a job. The outline that I provided, frankly, reflects kind of the history, really going all the way back to 1986. But, most of it really reflects the 2014 rule. I believe that that there was a rule review done in July of last year, but I'm not aware of there being any significant changes to wage loss. If anyone is aware, please make me aware of it. I didn't catch it. Before maybe I should have gone over with this, Angie, before I started talking. I do have this sheet that you used that showed some of the things you went over last year. Was there anything that you emphasized or focused on when you talked about wage loss last month?
Last month was a very general overview. We did look at the forms that you have to fill out and that are required, but it was just a real general overview.
Okay. So, the way I'm going to try to handle about the 50 minutes more that I'll talk, unless Angie cuts me off before then, which is okay, about wage loss, I'll probably spend a little more than half the time going over what I think are some of the important criteria, maybe even adding some comments generally about my experience. And then I thought it would be effective to kind of do a case study. I redacted the names, and the claim is almost 10 years old, and technically it wasn't decided because, frankly, the claim ended up settling before it went to hearing. But what was neat about this claim is that it involved non-working wage loss. It involved working wage loss, both for a salary position and self-employment, and also someone that had a very interesting resume, not your average claimant, at least that I deal with, So I thought it was a great example, at least to go over with you how I approached the defense. Now, again, it wasn't actually litigated. It would have been kind of fun to see what would have happened. I would like to think that and I should have mentioned at the very beginning, our firm only represents employers. So I have literally almost no experience representing claimants. So my perspective is purely from a defense perspective, though I'll try to make sure my comments are, somewhat even-handed about this, though, my focus on this case study really will be about how I approached, the different defenses that I felt could be developed regarding both non-working wage loss and working wage loss compensation. So, starting off with wage loss compensation, I mean, the concept is actually, the general concept, I think, is relatively simple. It's normally a situation where, it doesn't happen very often that a claimant hasn't already received temporary total compensation. I guess it can happen. The most classic example where maybe there's no TT paid is where an employer, voluntarily puts the claimant in a lower paying position because of an injury and frankly agrees to pay the difference between what their wages had been over normally a number of years, but certainly the last year, the average weekly wage, and pay them 2/3 of the difference. But that doesn't happen. In my experience, that doesn't happen that often. If it has happened, that situation hasn't been brought to my attention. So, I know Angie went over the basics last month. Hopefully you'll never get into the situation where a claimant could be paid up to 226 weeks of wage loss. That would be a situation where they got a full 52 weeks or at least 26 weeks of non-working wage loss, and then got either if they got a full 152, you can do the math, another 74 weeks of working wage loss, or it could be 200 weeks. But again, hopefully you're never going to run into that situation. That seems like a long time for someone to be able to get wage loss. I think it's particularly true. One of the things I'll talk about are labor conditions. Right now, I think the labor market is extremely strong, and that, if you have a situation where there is a claimant that's seeking non-working wage loss or working wage loss compensation, where there is a significant difference between what the claimant was making with the employer and what the claimant is making now, it would be a very rare situation that I wouldn't be recommending contesting either non-working or working wage loss compensation. I think a claimant really would you would almost force a claimant to really show that he or she has made a very diligent effort to eliminate that wage loss. And unless the restrictions are really, really significant, and the claimant was, at the max, and it's just not, it's very apparent that the claimant can't make even close to the wage he or she was making before, unless that situation exists. That's an issue that really should be going to hearing, in my opinion. If you go on page 2 of the outline, where we're talking just about the rule, whether or the rule from 1987 and even the more recent rule, it really hasn't changed. One of the most important criteria is that the restrictions that the claimant's doctor would be relying on is a direct result of the allowed conditions in the claim, because that is not always the case. Either the claimant, the physician, the claimant's counsel typically is using, is being a bit slippery about where the restrictions are coming from, or there's a legitimate dispute as to whether some of those restrictions even exist, or they're due to the allowed conditions. An example could be a claim is allowed for a low back strain, and it's apparent that the claimant has more serious pre-existing low back conditions. Maybe the most classic is arthritis, or degenerative disc disease. And if enough time has gone by, a legitimate issue is raised, whether those restrictions are still flowing from the lumbar strain. On page 2, it just talks about different situations where wage loss is payable. Again, the classic ones are either non-working wage loss where they haven't returned to work, or they have returned to work if it's with the employer and the employer has made the job offer, and there's really no dispute about restrictions, then there really isn't a dispute as to wage loss. If a job offer has been made and the claimant has turned it down, certainly it has to be in writing and meet the criteria. I'm not going to go through all the criteria about that. It's really similar to what you would have for temporary total, just to make sure it's detailed and specific enough. Going on to page 3, where the most recent rule, first starting on non-working wage loss. There's really not much, frankly, it goes into maybe a little more detail than before. It says must be the direct result of physical and or psychiatric restrictions caused by the impairment that is causally related to the allowed conditions. Again, most of the time, if you are going to be contesting wage loss, you're going to likely have a physician of your choice examine the claimant and address the issues of what the restrictions are and whether they're really flowing solely from the allowed conditions in the claim. A little further down on that page, maybe the most important definition that you find in the wage loss rule is suitable employment. And it's really a very general definition. It says suitable employment means work within medical restrictions, subject to all physical, psychiatric, mental, and vocational limitations to which the claimant is subject at the time of injury. So, obviously, if let's say there are some medical restrictions that even your doctor, the employer's doctor, or the reverse, the employer's doctor indicates is due to the allowed conditions, but you still feel there are issues about what the claimant has done to try to eliminate the wage loss, like what type of job they found, or if they haven't found a job, whether they're really looking for the right kind of jobs, or even if they're looking for the right kind of jobs, what kind of effort have they made and what kind of documentation have they submitted regarding those alleged efforts? Consistent, sincere, and best attempt to obtain suitable employment. That's obviously that's a vague requirement, and there's more specific requirements that you really can test that. And then must search for suitable employment, which is comparably paying. That means they really should be trying to totally eliminate the wage loss. If you have a situation where they come fairly close to eliminating it, it's probably going to be a waste of time to contest. If they come within 50, 75, let's say their average weekly wage is $700 or $800 a week, and they find a job that's within $100 or less of that, it's probably going to be a tough burden to meet to show that they haven't done enough. So usually these wage loss disputes, there's much greater disparity. Certainly the case study that I'm going to talk with you about, you'll see that we're talking that, the income level they were claiming was anywhere from quadruple to triple the difference. It was much, much less than what the average weekly wage was. Going to page 4 of the outline, where we talk about working wage loss. Trying to see where I talked about. I already missed that. All right. Guess I already talked about non-working. I guess I should comment a little more about that. On non-working wage loss, and they'll probably flow into some of the other criteria that I'm going to talk about, especially in their strong labor market right now. And I realize things could change, and maybe it depends on the area of the labor market. Maybe some areas are stronger than others. But I think a claimant that's claiming an extended period of non-working wage loss, I realize things have changed, certainly when, I haven't had to look for a job for a long time. I realize that in-person interviews are much less frequent than they used to be. And then even use of the mail to send resumes in, almost everything for many companies is online. I realize that. And, the wage loss rule that went into effect in 2014 and the current version, I think reflects that, in that, at one time it was a big deal about how many in-person contacts someone had when they were looking for work. Were they just papering it and they really weren't interested? I realize now that criteria may not be as relevant, even though I think in some areas eventually you would hope they would have some in-person interviews. But I think then it comes down to the kind of documentation the claimant has provided to show what they've done online, and also what kind of follow-up they've done online, and also what kind of jobs they're applying for online. And also whether it's, an employment area that it's still very common that in-person interviews are done early on, or are they done at a later stage? So I still think the number of contacts, the quality of the contacts, the follow-up, the type of jobs the claimant's pursuing, the first 60 days, the rule still, expects that they apply for work in the air, really in their skill set area. But if that's not working after that time, they're supposed to expand it to really other areas. So that's to be looked at. And, more of a general view, does it make sense that it's taking this long for them to find work? When you consider their educational level, their job history, and again, what the job market is like, especially in the area that they live, obviously in the Columbus area, but I think in many areas of the state right now, the job market is pretty strong. So then you have working wage loss on page 4. First, that they return to suitable employment. Again, does it make sense? And you'll see this in the case study that I'm going to talk about a bit. Does it make sense, the kind of job that they say that they've got or what they pursued? And then again, an important issue is whether the working wage loss is a direct result of physical or psychiatric restrictions, from the allowed conditions. And those are the main things I think I'm going to talk about on page 4. There is I guess it's worth mentioning it. I actually had this issue come up recently where there could be working wage loss for a situation where a claimant legitimately cannot get a medical appointment for treatment of a allowed condition during their outside of the workday. It has to be during the workday. If the claimant can meet that burden, the employer may have to pay them, basically, some employers will just pay them their wages, but otherwise basically to pay, 2/3 of the difference in the form of working wage loss. I guess if they had repeated medical appointments because of a condition and they couldn't do it outside of the workday, it might make sense to actually pay working wage loss rather than just pay their full wages. Going to page 5. I know Angie went over the forms last month, but certainly it's important that you make sure that they've really met their minimum burden, especially the job search forms. A lot of times a claimant will cut corners, and maybe they'll cut corners because frankly, they're really not doing a sincere job search. They're just trying to make it look like it is. So if it is a legitimate job search, you should do everything you can to either vet it or, challenge the fact that the claimant has not provided sufficient documentation on their job search forms to show that they've done a good faith job search to eliminate their wage loss. You know, towards the bottom, page 5, you know, the form that the Bureau provides. Again, I think that now we're dealing more with online postings and in-person contact, but there should be enough information that you have the ability to at least do some verification if there's a question about whether this is a legitimate job search or not. Going to page 6, you know, some of the prerequisites, obviously, they should apply for work with the employer unless the employer has made it clear that the employer doesn't have an alternative position. Register with the Department of Job and Family Services. And as I mentioned, about after 60 days to expand their job search to include entry level and unskilled jobs. For non-working wage loss, and this is an issue I'm also in the case study that I'm going to go over. It's legitimate also to try to ascertain how much time has the claimant spent looking for work. If the claimant had a 40 hours plus a week job or hours per week job, I think it's reasonable to require that claimant spend, I don't know if it has to be 40 hours a week, but still a lot of time looking for a job, especially in the current environment of this job market. So I know sometimes it may not be that simple to figure that out, but that's something also that maybe has to be brought up at hearing by counsel for the employer about how much time they really have spent, and compare that to the you know, if they had a part-time job, then I think the expectation is that they don't necessarily have to look beyond the number of hours that they would work in that part-time job. Other factors to be considered, and I think this is a classic example where you can really be creative in defending wage loss applications, because some of these criteria are very broad, like the claimant's skills, prior employment history, and educational background. So, you know, you can do, frankly, if a claimant is alleging that they cannot find work in the area that they were working in, and they had to take a much lower paying and more entry-level type job, I think that you may have to do your own due diligence and try to figure out what kind of jobs there appear to be out there for the skill set that the claimant has and the restrictions that the claimant has. As I mentioned earlier, the number, quality, and regularity of the employment contacts is something that should be considered. The claimant's refusal to accept job search assistance, I think, is a fair factor to address, because you got to wonder what the claimant, that's on page 7. Thanks, Angie. You got to wonder really why is the claimant not doing that? And that one I mentioned, labor market conditions. To me, I don't know if any of us are going to see very many wage loss claims right now, but I guess you could see some. I think non-working wage loss for an extended period is the most questionable right now. I realize if someone has restrictions that are debatable, that you may have a situation where they claim that they cannot, like, let's say they're in a more physical area, but that, you know, certain truck driving positions that involve lifting or maybe other manual jobs. If you can't do some of the physical requirements, that the jobs out there are going to be lower paying. So you could see that kind of issue come up even in a more robust labor market. A claim, you know, I mentioned a claimant's recent change of residence. You know, there's some case law out there about where if a claimant relocates really for personal preferences and puts them in a situation where, you know, the type of work they're doing before is no longer available, it could be a legitimate defense that, you know, the claimant has made a lifestyle choice and that it really has nothing to do with their allowed conditions or any of their restrictions. Economic status impacting on ability to search for employment. I guess that can come up with people that have lower economic means where they don't have a car, they have to use a bus. And you would think most people these days have, or at least have a cell phone. But I guess computer access is obviously very important. But normally I would question most of this because I think that's much less common these days. That individuals would claim they don't have that type of access. Part-time employment, you have a situation where a claimant was working full-time and the claimant finds a part-time job. Most of the time you want to challenge that. I guess there could be legitimate reasons where they could only, that part-time, maybe it flows from their restrictions, but most of the time that's something that should be challenged. Whether the claimant search restricts employment sought to fewer hours per week than the foreign position employment I talked about. Failure to accept a good faith job offer of suitable employment. Most of the time, I mean, that's going to be typically from the employer that you're representing. I guess if you somehow, normally you're not going to know, but if you somehow found out that a claimant got a job offer from another company and didn't accept it, that certainly would be something that you want to vet, because it would have to be a darn good reason why they wouldn't have taken that offer. Let's see what else we have here. Going to page 8. Voluntary retirement. Obviously, if the claimant completely removes themselves from the active workforce, that would be unusual that they would be applying for wage loss compensation. I think that's more common when they are either applying for temporary total or permanent total, but I guess that could possibly come up. But again, if that is an issue, probably the most important thing is going to be the connection to the allowed conditions in the claim. An interesting one is where a claimant has obtained part-time employment, but the claimant is maintaining that there are prospects that it's going to become full-time. I guess that could be a legitimate contention. I think the case involved is the Brinkman case that I actually cited in the case study that I talked about, or I will be talking about. The Brinkman case discusses where I think it was someone that was working at Anheuser-Busch, if I remember correctly. And they were claiming that they expected that the part-time was going to become a full-time position, and that it was too good a position to give up, especially when they claimed that within a given period of time, I don't know if it would have been a number of months, they expected it to become full-time. Maybe there was a certain probationary period they had to fulfill. But I think most of the time you still want to question that, because especially in a more robust labor market, whether that's really the case. But that could be something that a claimant could prevail on in, I think, limited situations. Then going to, from the bottom of page 8 to page 9, self-employment can be a very interesting area to deal with when it comes to working wage loss compensation. Excuse me. Because one of the hardest things as an employer is, especially if there is a significant difference between what the self-employment employment earnings are and what the claimant was making in the job, the position they had with the employer, is it's so difficult. A lot of it, you're in a way relying on the good faith motivations of the claimant. What are they doing in this self-employed job? Are they really trying to make an income that would be relatively close to it? Or is this just, frankly, an excuse where they really aren't doing much. They're limiting their income, and they're creating a very large wage loss. What efforts did they make to find jobs that weren't self-employment beforehand? Unless the self-employment earnings are close to what they're making before, what efforts are they making to continue to find work? And then whether the earnings they're claiming are legitimate. You know, are they submitting tax records to show what they made? Or is this an internal document that may be very questionable? And also whether the self-employment really meets their skill set. And again, have they demonstrated that really this was the only alternative for the claimant? Now, again, if they're making almost the same amount of money before, then it, you know, and you may not get anywhere contesting it. But otherwise, I think most of the time in self-employment, you want to question it because there's just so many variables, and there's, frankly, from my perspective, too much of an opportunity of abuse by a claimant. Going to page 9, you know, there's usually not very many offsets available when it comes to wage loss. One thing going back to page 8, I should have mentioned there is a rebuttable presumption that if a claimant is alleging that they're not making much from their self-employment, that there's a rebuttable presumption that their gross income is at least 50% of the statewide average weekly wage. So that is, you know, if for some reason, you know, you can't otherwise defeat the working wage loss, you certainly want to rely on that criteria to force the claimant to show. I mean, the claimant can show that it's less, but that's a rebuttable presumption, which is often not easy to meet. So again, government income, it's not often that you're going to be able to use any kind of offset. Computation of wage loss, sometimes it can be a complicated issue. If the claimant is not making a straight wage, that there is commission involved. The case study that I'm going to be starting soon, the initial salary job that the claimant came up with was a car salesman position that did involve commissions. And so that can actually make it fairly complicated, and you certainly have to, you know, insist that there be, if there aren't any other defenses and that it's simply a matter of computation, you certainly want to make sure that everything is considered, and commission, sales, bonuses, gratuities, other compensation. They might get some salary in addition to their commissions. Let's see what else here. It can get really complicated if there's an offset involved. I mean, normally you're hoping that wage loss will be completely denied. But if a hearing officer would take the approach that they're still entitled to wage loss, but that the difference is less, then some of this criteria is going to come into play. You know, if they didn't accept a good faith job offer of suitable employment, but that job still paid significantly less or even somewhat less, then you're going to still have to figure out 2/3 of the difference of that. If there are indications that the claimant voluntarily limited the number of hours, again, you're going to have to try to come up with calculations on that. I wouldn't just go there, though. I would try to get the application completely denied, but I realize that you know, a hearing officer may not want to go there, and that you may have to have this alternative approach ready when it comes to calculation of working wage loss. Let's see here. Going to page 11, some self-insured employer issues. You know, you got to adjudicate it within 30 days. You know, if you as a self-insured employer is contesting non-working or working wage loss. You have to file with the Bureau at that time. Typically you're dealing with AWW. I think most of us don't have claims before 1997 anymore, so I wouldn't worry about that. Some strategies for controlling wage loss. I'm not going to go in great detail because I think it'll come out in the case study. An interesting issue, though, comes up about returning to the former position of employment or modified work. What if the claimant is actually fired by the employer and the employer maintains it's for cause? That could be a defense to a wage loss application, though there's the Schottenstein case that I'll give you the site too when I get to it, that, unlike temporary total, a firing from an employer often will not be a defense. So you should be aware of that. There are limited circumstances that the court was not, I think it was the Supreme Court. Let me see if I can find it here. I don't think the Supreme Court was, here wasn't that I found it. I'll get you the site to that. Maybe it's here. That a firing they just weren't willing to go that far. They felt it was too broad. Let's see here. Going this way, page 12. Or even the bottom page 11, rehabilitation program. Again, you can offer vocational rehab if you think it'll help. If the claimant refuses to consider that, that certainly could be a defense. Issue of causation. Again, the allowed conditions could be an issue. There's case law that talks about there that they took part-time work, that full-time work is not available. On page 12, medical evidence, vocational evidence. If you're talking about a lot of money here, it's certainly worth not only to have the claimant examined by a physician, but to also retain a vocational consultant. In the case study that that I'm going to start in a moment here, we used a vocational consultant to address the type and number of job contacts the claimant was using, and frankly, the type of jobs that were available to the claimant with his skill set. Investigative evidence. In my situation that I'm talking about here, the employer did have an investigator do some monitoring and actually had some video surveillance that showed the claimant was very active physically. I think he was playing volleyball with one of his daughters, and we supplied that to our doctor, and that helped solidify our defense regarding just what the legitimate restrictions were from the allowed conditions in this claim. So that's certainly another option. Going to page 13 again, a lot of these things I've talked about the job search, the claimant's physical capabilities, whether the claimant's inability to find employment is due to other factors, criminal record, lifestyle choice. They're not allowed to drive a truck anymore. Let's say they've had drunk driving convictions. These are all legitimate issues that could be raised about what is really preventing the claimant from finding suitable employment that's comparably paying. Abandonment, again, here it is. On page 13, the Watts Schottenstein Stores case is actually a Supreme Court case in 1993. But to my knowledge, that there hasn't really been significant case law that has really modified or dramatically changed it. So even though I wouldn't give up the issue of the employer's firing of the claimant, realize that there's a good chance that will not be recognized as an absolute bar. Just above it, the Reamer case, if the claimant voluntarily removed himself from full-time labor market, a full-time student, and limits himself to part-time employment for reasons unrelated, certainly could be a basis for denial of working wage loss. So let's go to in the 15 minutes I have left, I'm going to talk a little about this situation that I had come up. Now it's hard to believe it's about a decade ago. I did provide Angie with a few of the documents that I had redacted. One was a brief that I did. Again, this matter did not go to hearing, but I think everything that I submitted helped get the claim settled for what was a favorable amount to the employer. I did include a brief that I had submitted and also an affidavit of the claimant, because it gives you an idea, with some redactions, it gives you an idea of some of the issues that came up in this thing. I'll try to give you a quick summary of what was going on here. The claimant was a truck driver for a large employer in Northwest Ohio, and I believe he claimed that he had injured his back while lifting garage doors, maybe not garage door, doors itself that you could actually carry. I think they did weigh close, they were of significant weight. So he actually received temporary total in the claim, I think, for a good 1.5 to 2 years. Eventually, he was found to be an MMI, but then he, through his counsel, pursued both non-working and working wage loss compensation. I believe he was non-working wage loss. I think that he sought was a couple of months, which may not seem that long. The labor market at that time, this is going back almost 10 years. The labor market wasn't particularly strong at that time. And then he got a much lower paying job. I think his average weekly wage was about $1,200 a week, but he was earning wages of about, I think that averaged out to about $400 a week as a car salesman. And then I think he eventually left that job. He claimed that it just wasn't working out, or he felt like he could make more money in self-employment. He was, it was hard to describe what he was doing in self-employment. I think it was a combination of promoting certain type of apps, and also that he was, I don't know, I used to joke about him. I don't know if you ever saw the beer commercial about the most interesting man in the world. Well, this guy kind of portrayed himself as someone that had done all these interesting things in his life. I think he was trying to drum up interest for a travel club in which he would get paid. So, but to cut to the chase on this thing, he only made on average of about $200 to $250 a week when he was working self-employment. So, the difference was almost the equivalent of what he was being paid in temporary total. So he was basically trying to get paid temporary total ongoing and still run this so-called self-employed business. So needless to say, we challenged both the non-working and working wage loss. We had the claimant examined by a physician of our choice. We provided the video surveillance to the physician. And of course, based on his examination and the review of the video surveillance, the physician offered an opinion that he felt the claimant could go back to work as a truck driver, that he shouldn't have any more restrictions, that the conditions that were allowed in the claim, and I believe the main condition that was allowed in the claim was a lumbar strain. So I think you can understand the employer's position here, where it was skeptical that the kind of restrictions that the claimant was making or was contending, and basically the conditions, the restrictions were that he couldn't lift more than 20 to 25 pounds, and that was only occasionally. There were restrictions on he could only stand 3 hours a day, could only walk up to 5 hours a day. These were some pretty significant restrictions. that you would wonder why a lumbar strain would be imposing this far down the road. In addition to that, we had a vocational expert address the number of job contacts. I believe he was pretty much doing only about 1 to 2 contacts a week. It was not a lot. So we questioned the number of contacts, also the quality of the contacts, because he almost immediately was pursuing entry-level work. He was really making no effort. What I haven't told you is this individual had a college degree in, I think, a Bachelor of Arts, but he also had some education in creative advertising. He had computer skills. So again, this wasn't your average truck driver. He had a lot of other skills. So we were able to get a report from a vocational expert that indicated that, the jobs he was seeking were well below his educational level and below his skill set, and that he should be pursuing jobs that frankly paid much more, and that he wasn't spending enough time when he was pursuing non-working wage loss, but even working wage loss. I was prepared to rely on that opinion because, I think it was very questionable that all of a sudden here he was claiming to be a full-time car salesman, and then all of a sudden he's doing self-employment where he was making barely half of what he was as a car salesman. So, in the brief that I had submitted to the commission, a lot of these factors identified, referenced, again, that the good faith job effort needs to be consistent, sincere, and best attempts, which we certainly maintain was not happening. I realized at that time there was more of an emphasis on in-person contacts and mail, but even now, then it would probably be more of online contacts rather than that. But certainly you would need a good explanation why your number of job contacts would have been that low, and also why they weren't in the area that the claimant was working in. It's also, I think, very suspicious when there is such a huge difference between the average weekly wage and what the claimant is making in this either part-time or full-time job. Even with the car salesman, there was a difference of about $800 a week. And our position would have been he should have been continuing to look for other work because he wasn't making much money as a car salesman. So it was apparent this was not going to be a career-changing job for him. A case that I cited was Yates versus Abbott Labs. It's a 2002 case. And again, I took a look the other day. There's just not a lot of case law that's been out the last 10 years. So a lot of the case law you'll find goes back 10, 20, 25 years. It really hasn't changed. In the Yates case, it made it clear that a claimant with considerable job skills could not simply take a significant lower paying full-time job with little opportunity for advancement and stop looking for comparatively paying suitable employment. And really the situation that we found in my scenario here, where it was a car salesman that it didn't look like he was going to be making much money. He had much better education and jobs, not to denigrate car salesmen, but, there never really was a good, very convincing showing of why he had to settle for that job. And that was it. And then to leave that job and then go into, the self-employment. I mentioned about the Brinkman case. There is an exception of a claimant not being required to leave too good a thing. But that exception we would maintain would not apply to a car sales position that had not increased in pay and he left after only 6 months. Again, regarding working wage loss, one of the things we were going to emphasize was his job skills. He had sales experience, marketing experience, delivery, driving, and computer experience. those job skills, work experience. He was a route driver, a regional sales manager in sales, and had college degrees. And I realize your average claimant for wage loss may need not be that high, the skill level and the experience level, but I think this is a good example to see the different criteria, how they apply. Then on self-employment, I realize I only have about 5 minutes left here. On State X Rel Uten versus Siegel, Interior Specialist, a 1998 case, 84 Ohio State 3rd, 255. Again, someone who has not really made much of a showing of the job searches that they've made both before and after the self-employment. The court made it clear that this alternative employment needs to be carefully scrutinized. If it's not regular, full-time work that's paying, close to comparable wages that they were making before, it's to ensure that the claimant's job choice wasn't motivated by really a lifestyle choice rather than by injury-induced unavailability of other work. And then there's documentation I mentioned before, and I provided to Angie, there were a couple of commissioner decisions that they talk about that the claimant had submitted, or their counsel had submitted, some internal documents that showed self-employment income, but there were no tax documents submitted. And the court, the commission, and even in the courts have indicated that the documentation has to be carefully vetted, and an internal document is usually not going to be good enough because you just don't know how legitimate that is. At least tax documents. Now I realize they could be committing tax fraud, but at least tax documents, you have more of reliability that at least what they're claiming that they've earned is legitimate. Of course, that still doesn't mean that you don't fight it for other reasons. But in that case, it's the sole documents submitted. This is the Uten case. Was an internal summary that he completed. He didn't submit any accounting or tax records that would verify the alleged income and expenses of his business. So, that's another thing in addition to many of the other criteria that I talked about. I wouldn't be quick to accept internal records submitted by a claimant or claimant's counsel for a self-employed business unless there are accounting and tax documents to back that up. So it's about 12:57. I purposely have limited the time you can ask questions. I'm joking. But if you do have any questions or comments, now's the time to do so. Angie?
Anybody have any questions? No? Okay. Let's see.
Do you have any questions, Angie? You and I have worked on wage loss issues many years. One thing Angie didn't tell you, she and I, we worked together at one time. So
for many, many, many years.
Many years. Then she got smart and went elsewhere.
Let's see. I would, if there was a question about whether the restrictions were related to the allowed conditions, other than, really you would have to rely on an IME.
You really have to, I guess, it's common sense to me, though. Look, the commission grants sometimes, usually they're not that large, but they grant PPD awards for lumbar strains that are a number of years old or increases. So you can't say that there is no residual left over from a strain that's several years old. Now, whether it would result in significant restrictions, I think common sense, you could question it, but usually you want to have an IME to say that these restrictions either don't exist at all or they're not coming from the allowed conditions. Otherwise, you run the risk that a hearing officer, there's a form that I assume Angie provided last week. It's what the C-140. I don't think they've changed the designation. This C-140 is more than 10 years old, but a physician for the, or chiropractor for the claimant filled this out, and it was based on the lumbar strain that was allowed in the claim.
Okay.
And that claim at that time was almost 2 years old. So that set off alarm bells when we got this.
Right. Okay, are there any other questions anybody has for Mr. Goldberg? Okay, well, I don't see any. We do want to thank everybody for your time and attention. We want to thank Mr. Goldberg for sharing his expertise with us. And as always, we want to thank Megan Rogers at Spectrum Reporting for providing our Zoom link and for recording today's session. I will try to, in the next day or so, get our next sessions put up on the events calendar of the website. So be looking for those next month. On March 16th, Attorney Doug Koppel will be joining us to discuss COVID claims. And on April the 20th, Attorney Karen Toronto will be joining us to talk about firefighters and the presumptive cancer claims. And what those requirements are and where we are with those claims. So as I said, I will be putting that information up on the website. Be sure to register, and thank you, everybody. Have a great day.